Oh, well, my attorney said that instead of doing a joint married AB trust, that me and my spouse need separate trusts. No, you don't. Hi, Jeff Marsocci, the Plain English Attorney, and welcome to a part 2 of Just the Facts, ma'am, where we go through facts regarding revocable living trusts and other estate planning things in bite-sized nuggets to make it a lot easier to digest. So let's jump in with that first question. What happens to assets outside the revocable living trust? Do they end up having to go through probate? And the answer is yes. This ends up coming down to a trust funding issue that I have to constantly keep in front of my clients. Most people like to do estate planning. They sit down, they get it done, and they go, okay, I don't have to worry about this ever again, or at least until something big happens and they need to make changes. But the fact is, you have to treat a revocable living trust kind of like a suitcase where, yeah, you've got this great structure and it's perfect for the trip that you need to take, but you got to make sure you're packing it. So if you're one of these people, and I know people who are, you take a big trip, you come back, you've got your suitcase there, you don't really unpack it. You end up, okay, well, I'll take the laundry out because I'm going to do the laundry now. Oh, but there's other stuff that's in there. Well, I'll take it out as I need it, and then you leave it somewhere else. And if you go on your next trip and you just pick up the suitcase, there's a lot of stuff that you had taken out over time. It's the same thing with accounts. People will end up changing banks, changing financial advisors. They'll come into some money and put it somewhere else or keep it wherever it was inherited from. The institution stays with it. But the problem is it's got to all be coordinated. And if you just leave it in your individual name, then it has to go through the probate court process. And that's what we're trying to avoid. So what does happen? Well, it ends up having to go through the court process, but the document that should be with every revocable living trust is something called a pour-over will. The pour-over will is what brings it through the probate process with only one beneficiary, which is your trust. So once it goes through that probate court process, it goes into the trust. The thing is, you want to minimize what has to go through probate as much as possible to make your trust as efficient as possible. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So that's a very good question. All right, what's another question? Okay, can probate be avoided with the use of joint tenancy? And the fact is it can, but this is what I call one of those duct tape solutions where it's just, oh, it sounds so simple, but it's like doing duct tape instead of an actual repair. It'll get you a little bit, but it's not going to be too much. Let's go ahead and do an example. All right, I have my house and I want to put my kids' names on the house because it's joint tenancy and then they'll inherit it. Perfect. What if one of your kids dies? It happens way more than we want to think, but it does happen. Oh, well, in that case, I would want it to go to my kids' kids, the grandkids. They would inherit whatever their parent wanted. Very, very common desire. Can't do that with joint tenancy. Or what if, well, I'll put my kids' names on it, but they're still kind of young and irresponsible. I don't want them to inherit it until a certain point. Nope, can't do that with joint tenancy. What if one of the kids gets sued? Okay, your house is on the chopping block depending on state law because now it's not protected. It's not only you and your lawsuits that may come against you that are a problem. It's one of the kids. There are just so many drawbacks. Another big one, if you have a house that's joint with a right of survivorship with the kids, you may not get a full stepped up cost basis when you pass on, meaning they're going to have capital gains taxes when they sell the house versus if it's inside a revocable living trust and then goes to them or gets sold and the money goes to them. The cost basis bumps up to fair market value on the date of death, so it's little or limited change or in capital gains taxes. So you may end up giving your kids a big tax burden just because you want to be very quick and simple and use the duct tape solution of joint property with a right of survivorship. Now, I'm going to go off just a little bit here to the side. There are some very good reasons to do joint tenancy with the right of survivorship with kids when it comes to Medicaid planning, but we're talking here just about avoiding probate. If it's just avoiding probate, joint with a right of survivorship is probably not the way to go when you could do a revocable living trust. All right, so what other questions do we have? Community property states. We're not going to go through that. There's a tax issue. Well, okay, in a community property state, there are only a handful of these states, and really the benefit in community property states for tax purposes is that assets get a full stepped up cost basis. Okay, so we have standard in our trust, even though North Carolina is a separate property state, not a community property state. There is a community property agreement that's stating if assets go into the trust and they happen to be in a community property state that they're going to keep that benefit. All right, is there any problem with transferring assets held in joint tenancy into the revocable living trust? All right, this is where we have nuances and situations that might be different. If you are putting something like a house into a revocable living trust out of joint tenancy with a right of survivorship, if it's a married couple and it's tenancy by the entirety, that's joint tenancy with a right of survivorship for married couples. You take that land and you put it into a revocable living trust that's also joint with the two of you, no issues. Even if there's a mortgage, no issue. There may be issues with the mortgage if it was your individual name going on the mortgage and on the real estate, and then you're moving it into the trust. Most of the time, the mortgage companies don't care if it's with a spouse, but they would care if it was somebody else. All right, if you're taking a account or some other asset that is just yours separately, and you're moving it into a joint revocable living trust, suddenly it becomes a joint asset unless you've got a separate property agreement that's simply stating, even though it's inside the trust, it remains separate. All right, so let's go on to another question. What happens if I own stock or real estate in joint tenancy with my children? All right, well, that's when we have some issues with having to move just your portion into the trust and there is no right of survivorship. This is something that is best worked out with the children, figuring something out. If it was joint with a right of survivorship, hopefully there was some actual legal reason that it was done that way and not just because, hey, let's do this quick duct tape solution of putting my kids on my house. There was an actual reason for it. And you might want to re-examine that reason with the kids now that you're putting together a revocable living trust. So let's go on to the next question, and this is a bit of a history that was explained to me by Henry W. Wapps III at one of the large conferences that we went to. Oh, well, my attorney said that instead of doing a joint married AB trust, that me and my spouse need separate trusts. No, you don't. Here are some of the issues that come up with this and the history behind it. Going back into the 80s, there was Henry W. Wapps III. So Henry was a financial advisor who wrote the book The Living Trust, which still, even though the tax numbers are wildly outdated, it's still a really good resource. He was kind of spreading the word about revocable living trusts as a way to avoid probate with an estate plan and cutting out a lot of the attorney's fees that end up happening when you're settling an estate. So he's out in California and eventually he moved into Nevada, but he was doing all of these seminars and workshops after he published his book going across the country, but he was kind of going from California and moving east. There were two other attorneys down in Florida who were doing the same thing, and they were lecturing and kind of going up through the South and into the mid-Atlantic states. And what ended up happening is these attorneys down in Florida were going, "Oh, no, you need separate trusts for husband and wife." And Henry's saying, "No, you don't need a separate trust. You could do one trust that has all the tax language inside, and it'll be just fine." Okay, so these two different philosophies kept going, and the attorneys kind of made it up to the upper mid-Atlantic states, maybe even a bit into New Jersey and New York. Henry's teachings went all the way across the country, kind of up to the Mississippi, and then up into New England. And so even to this day, you will see attorneys in those southern or mid-Atlantic states go, oh yeah, you have to have separate trusts. Why? Well, because that's what we've been told. That's what they've been told way back into the 80s, and it doesn't make sense. So why doesn't it make sense? Well, okay, if you're going to have separate trusts for a husband and wife, the usual reasons are because it's probably a second marriage, it's probably later in life, they each have their own kids, they want to incorporate each other into the plan, maybe leave them something. It's very common for my clients to say, yeah, we want to avoid probate. We don't want the kids to fight. I've got my stuff. They've got their stuff. We're going to have a house that's jointly owned. But that's it. We have completely separate plans, and we want each other to be like the primary trustee for each other, but we have separate people after that. Okay, that's such a different plan that you do want two trusts to do that, but at the same time, it's going to be coordinated. So in that sense, it makes sense. So you put half the house into each trust, and there are provisions in both trusts saying, oh, the surviving spouse, no matter who it is, gets to live in the house, but when they pass on, all right, the house gets sold, those separate trusts end up getting half the value of the house in the house sale. So the value of the house doesn't go to the other spouse's kids, it goes to your own kids. So that's the way it works out pretty well if you've got two separate trusts for a married couple. Other than that, there really isn't a reason to have these trusts be separate for a married couple if you're kind of in line with, okay, you can come to a common list of trustees, you figured out here's where you want things to go, and maybe there are separate things that you want to go to separate people, even if it's a second marriage. Even in that case, you can simply have a separate property agreement that says, okay, we're going to do a lot of this stuff together jointly, and it's going to go into the trust, but this is this person's separate property that's got to go to their kids. This is this person's separate property. It's got to go to their kids. That's fine. The reason that the attorneys down in Florida are saying, no, you need to do separate trusts is because of estate taxes. Okay, right now the estate tax limits are about close to $13 million per person. There aren't a ton of people affected by the estate tax, but if you were, or if your state has a lower tax threshold, and we do have a link that we'll put into the description in the video about which states have their own separate estate taxes. If you have that lower threshold, you want to make sure you're taking advantage of both tax credits. All right, well, that's why they were saying you need separate trusts so you could do the separate tax credits. No. You can combine this into one revocable trust document that has all the tax language upon the first person passing on, the first spouse passing on, so that we're utilizing their tax credits in this. And what happens is the math is all being done inside the trust at the time it's needed. What happens if you have separate trusts? Oh, well, we need to make sure we're balancing out this estate. So you can put the house there, but you've got your stocks here and this and that next year. Oh, well, stocks did really, really well. Real estate went down. Okay, we got to move some assets over here. And so it becomes this balancing act over potentially decades to try to keep the trusts of equal value to utilize the estate tax credits when all the math can be done inside that one joint Married ABC Revocable Living Trust. So there really isn't a reason to have separate trusts unless your plans and the people you want as trustees are going to be wildly different. So very good question. Let's see. Is a living trust valid in all 50 states? Well, this is more of a state by state question for the attorneys in that particular state. Now, what I can tell you is revocable living trusts are much more universal than wills, and certainly more than powers of attorney and healthcare powers of attorney, just because trust law kind of became kind of homogenized. Well, you still need, if you're going to open up and prepare a revocable living trust and execute it and fund it in one state, and then you move, you still need to have it checked out. Now, some states and some attorneys, they do the very simplest, barest job that they know how to do, and they use very, very state-specific documents, and there's some language that needs to be included, or it's very, very specific to that particular state according to such and such section in this state's law. Okay. The trusts that we do are meant to be much more universal so that, yeah, they're valid in all 50 states. But if you enact one in North Carolina and say you're moving out to Wyoming, you want to have it reviewed by a Wyoming attorney just to make sure there isn't some quirk that came up and, yeah, we need to put some additional language in here. But what I can tell you is, at least with the trust that we use, if you send this out, if you go to an attorney and they look through this and they go, oh, we got to scrap this and start over, find another attorney. Something that goes along with that, though, if you have moved to another state and you've got that healthcare power or financial power of attorney, and whatever the state has as far as a living will or advanced directives regarding life support, you definitely want to get those documents redone for that particular state. Not because it's not necessarily invalid, but because banks and financial institutions are used to seeing a durable general power of attorney done a certain way in that state. Hospitals and healthcare providers are used to seeing a healthcare power of attorney and a living will done a certain way in that state. So you want to get those documents replaced if you are moving to another state. But as far as the revocable living trust, is it valid in all 50 states? Well, if it's done right, it should be, but you always want to make sure you get a second opinion when you move to another state, just to make sure. Okay, here's a good question regarding international, and I really try not to go international with advice when I'm giving it to my clients, but this is not legal advice. This is just general information. Check it out for your particular situation. Is a living trust that's been notarized in the United States valid in other countries? Depends on the countries, but under the Hague Conventions, yes. Generally, it should be, but there may be some specific treaties that are in place regarding revocable living trusts and other legal types of documents and their acceptance in different country to country. So if you're in the United States and you're going to another country to move and live there, and you're just moving everything, well, you really should check it out with an attorney in that country, because there's a lot of treaties between the U.S. and that country, and that may be completely different between the U.S. and another country, and the U.S. and yet another country. Check it out just to make sure. All right, I did a video on this next question that goes into a lot more detail, and we'll go ahead and we'll put a link to that one in the description. What's the difference between a revocable and an irrevocable trust? Well, if you want the detailed answer, check out that video, but just in general, a revocable living trust is meant to avoid probate. So you can put all of your estate wishes in there, move your assets in there, maintain control over them, and when you pass on, it goes where you want it to go, and you can change it anytime you want. Now, an irrevocable trust, there's got to be some tax or other reason why you want that trust to be irrevocable. You're putting your assets in, and in a lot of cases, you're giving up control as the trustee in order to get something in return. We used irrevocable trusts a lot when we do Medicaid planning in order to qualify for Medicaid for nursing home care. So that involves taking assets, moving it into an irrevocable trust, and stepping back. In most cases, when we're talking about assets, bank accounts, stocks, other liquid assets, personal possessions, it's going into an irrevocable trust. You've got someone else as the trustee. Technically, you're not even the beneficiary, but you're putting in place trustees who will take out, put into an account, and then give you money or pay for things for you from this other account. So you're technically not even the beneficiary of this irrevocable trust. Well, why would you do that? Because you see there's an issue coming with Medicaid down the road. There are other irrevocable trusts that we use an intentionally defective grantor trust so that we can put your real estate into the trust. Someone else is the trustee, but you're retaining the right to live in the property, the right to any income generated. You still pay the taxes and keep the upkeep and insurance and all that other stuff. But after 5 years, it kind of drops off of Medicaid's radar as being yours, where you have to either spend it down or have it be available for a lien on the other end. So giving up control and giving up possession by moving stuff into an irrevocable trust can have some advantages in terms of like Medicaid planning and lawsuit protection, depending on the state and how it's set up. But you don't generally want to say, oh, I just want to do an irrevocable trust because I know I am never, ever, ever, ever going to change my mind on this, because it happens all the time. Let's just do an irrevocable trust for estate planning. There isn't a reason to. Okay, last question in this section. How is a revocable living trust named? Now, there are many purposes to have it done differently, but the big thing is you want to make sure that your name is somehow incorporated into it so it's an identifiable trust. And then your names are listed as being trustors and or trustees, and the date of the trust is involved. So you can name the trust the Smith Family Trust, dated whatever the date it's signed. John A. Smith and Jane D. Smith, trustors and or trustees. Well, why would you have that big, long thing? In our experience and our experience with other professionals, there are sometimes banks that get a little bit fussy and they say, oh, the date of the trust has to be part of the name of the trust. Okay, so we have the date of the trust listed in there. Now, this is an outdated one. Oh, well, you have to have the name of the trustees because technically you're not moving it into the trust as an entity. It's under state law. It's technically going into the name of the trustee. Okay, that's splitting a legal hair that became so annoying that even the North Carolina legislature said, no. Oh, God, stop this. If you're moving it into the name of the trust, it's presumed to be for the person who's the active trustee. Knock it off. But there is still some institutions that remember that old kind of fussy rule. It's like, oh, well, you don't have the name of the trustee as part of the name of the trust. We can't work with you. And then there's still another, which this one doesn't make any titling sense. It's, oh, well, this is a revocable grantor trust, so we need the name of the grantor or the trustor to be part of the trust. All right, that takes care of all three of them. So that's kind of the standard name of the trust that we use. Maybe sometime there's a reason that they don't want it done that way. And if so, okay, we'll go ahead and figure something else out. But they may have some difficulty and almost definitely would have to have a copy of the trust given to the financial institution if they're going to fund the trust properly and move their assets into the name of the trust. All right, so if you haven't already, please subscribe to the channel because it does help us get this information out and keep all of these videos free to the public. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.